Hello, good and wonderful people. Welcome back again. It's your girl, AB World Entertainment. Good morning, good afternoon, and good evening. Depends on the time you guys are watching me from. Today, I bring to you about the summon of President Muhammadu Buhari to NASS meeting about wetin dey go on for Nigeria for the insecurity wey dey happen for inside ogbonge Nigeria. So na the meeting dem dey do since now. I say make I let una know say the president of Nigeria, President Muhammadu Buhari, the first citizen of Nigeria, he don already for about the insecurity, about the kili and the kpai wey full for Nigeria. Na make dem come summon am say make him come answer some query. You understand? You need to still address the youth and everything. So you understand? So for this session 218 subsection 1 of the 1999 constitution, which stated that the management and the control of the security section exclusive vetting in the presidency as the commander-in-chief of the armed forces of the army force, including the power to determine the so the chief operational use of the army officer force. So na the matter na dem still dey talk about they no get right to summon President Muhammadu Buhari. You understand? Say as a president is not in law to summon am. You understand? Hence, that is in the sense say they not go dey meet. Now they supposed to go meet Buhari. No be say they go summon am put for matter. So the senior advocate of Nigeria come still talk about you say he can still talk how to move the country forward. You understand? Say President Muhammadu Buhari to be someone, not be bad thing, but not who make the law. You understand? He say with respect to which it has the power to make law and the contract of the affairs of any person, authority, minister or government department change. Or you understand? So how to make Nigeria go forward? Now make them say make them summon President Muhammadu Buhari. And now waiting the matter where they talk for the parliament today na be that one. So another basic constitution say he say there is no basis for compassion between the fake presidency system of the government we practice in Nigeria and the parliament system that is practice in British. Another person come to talk say they no fit summon President Muhammadu Buhari. Say if na UK you can never summon the Queen, you understand, to the throne to come talk about wetin dey happen, the insecurity and everything. So now make this person come to talk say now that is they no fit talk say they no fit summon am. So you cannot use British country take compare to Nigeria country. You understand? Their laws and the way they do their things, you cannot use it to compare Nigeria. Oh, you understand? So now wetin happen na be this very one. Now I say okay, I need to just bring the matter come una way my country people. So say someone President Muhammadu Buhari not be bad thing, you understand? Because ever since he come into the government for the second tenure, he never come outside to address the issue. Okay, just look at the issue of the Likki Toge massacre, and also look at the issue of the rice farmer that were killed in Borno State. You understand? So President Muhammadu have not come out one-on-one to speak with the people or even to speak with the youth. You understand? To give them their 5-point agenda that they demanded. You understand? So today, finally, President Muhammadu Buhari have finally come out to address the issue. So my country people, I'll be putting the video for you people to watch how the meeting went. So before I put the video to you guys, let me first and foremost say hello to the full house. Please, if today is the very first time of coming across this video or you have been watching, you have not subscribed, please kindly do by hitting the notification bell so that anytime I do upload any new video, you'll be the very first person to be notified that I just uploaded a new video. By doing so, God Almighty will bless you. To my new subscriber, thank you very much for being a plus to this great family. And to my returning subscriber, may God Almighty reward you for me in Jesus' name. Please share this video and give it a like if you like the topic. Leave a comment for me in the comment section. I will get there. I will reply you. Thank you, everyone. Choose.
Showing on this episode of Law Weekly, reactions continue to trail the legality of the invitation extended to the president to appear before the National Assembly to brief it on the security situation in the country. We have the views of a senior advocate of Nigeria, Yemi Johnson. Also showing on the program, highlights from the opening ceremony of the 2020 Annual Conference for Justices of the Court of Appeal, plus our weekly recap of the news from the courts and the judicial panels of inquiry into SARS abuses and police brutality. Hello and welcome to the program. I'm Shola Shieli. On the 1st of December, members of the House of Representatives passed a resolution to invite President Muhammadu Buhari to brief the lawmakers on the true state of security in the country. The decision to summon President Buhari was taken at plenary when the House considered a motion moved by members from Borno State on the recent massacre of 43 rice farmers in the state by Boko Haram insurgents. On Monday, December 7th, the president's personal assistant on social media, Loretta Onoche, announced that the president will address a joint session of the National Assembly on Thursday, December 10th. But on Wednesday, December 9th, the Attorney General of the Federation and Minister of Justice, Abubakar Malami, SAN, released a statement to the effect that the National Assembly has no constitutional power to summon President Buhari. According to him, the management and control of the security sector is exclusively vested in the President by Section 218, subsection 1 of the Constitution as the Commander-in-Chief of the Armed Forces, including the power to determine the operational use of the armed forces. An invitation that seeks to put the operational use of the armed forces to a public interrogation is indeed taking the constitutional rights of lawmaking beyond bounds. Reactions immediately began to trail this statement. Senior advocate of Nigeria, Femi said that having accepted to appear, President Buhari is under both a moral and legal obligation to honor the invitation of the National Assembly. According to him, by the combined effects of Sections 88 and 89 of the Constitution, the National Assembly is empowered to summon any public officer, including the President, in the course of conducting an investigation into any matter with respect to which it has the power to make laws and the conduct of affairs of any person, authority, ministry, or government department charged or intended to be charged with the duty of or responsibility for executing or administrating laws enacted by the National Assembly. But another senior advocate, Professor Ernest Ojukwu, in response to Mr. Falana's comment said, immunity protects the president from the investigatory proceedings envisaged by Section 89 of the Constitution, which is quasi-judicial in nature, and its summons enforceable only by warrant. He was therefore of the view that the immunity enjoyed by the president under Section 308 of the Constitution, under Section 308 of the Constitution, protects him from summons whether issued by the National Assembly, the courts, or anyone else. For Professor Isha Sage, summoning President Buhari amounts to denigrating the sovereignty of Nigeria. He also reminded the lawmakers that the British Parliament cannot summon the Queen to respond to any issue. But another senior advocate of Nigeria, Ferdinand Obi, has faulted Professor Sage's stance. He says there's no basis for comparison between the fake presidential system of government we practice in Nigeria and the parliamentary system that is practiced in Britain. President Buhari is not the king of Nigeria, and there is no king under our constitution, he says. Of course, it's no longer news that the president did not appear before the National Assembly. But on the program today, I have another perspective. My guest is Senior Advocate of Nigeria, Yemi Johnson, and I spoke to him about these and other issues.
I think it's a sterile argument. The law says something. I believe that he can be summoned. I believe that in the way the constitutional law operates, it's a distraction to dwell on the legality of the summons. The critical issue is whether the president is responsible for the failures of his government and whether he should seek the first opportunity to discuss this in a public forum. The fact is that a president under democracy under the Constitution must be accountable. If you say that a major national disaster has occurred and you don't need to discuss it, you don't need to respond to a summons, even an invitation, even a suggestion, suggests a failure of executive responsibility. That's really the way I see it, you know. But the law is clear. Legislative Powers Act says you can subpoena any person. But in other countries where they can subpoena an individual, it depends on the willingness and the effectiveness of the summons. If you summon the President of the United States, it's exceptional. I mean, I think one president has been subpoenaed during his tenure, and others have been subpoenaed after. But there's always a problem about it, because different branches of government under its constitution, which separates power, must naturally defer to each other in the area of their power. So, for example, it would be unusual for the National Assembly to subpoena the Chief Justice to discuss a case going on before the Chief Justice. And if a court wanted to subpoena the National Assembly, they're unlikely to subpoena the Speaker. They may subpoena the Clerk of the House. So this is not, these are norms of the constitutional practice. And the people who operate in them should understand that those norms can be adjusted as is necessary. The important thing is that, are you accountable to the people? Is there a crisis and national question which requires you to answer to the people? What is the forum you choose? The President hasn't made any public speech on these issues. The National Assembly considers this security to be a primary function. And security is a primary function of any government. And they say, we invite you. Then we get into this idle and sterile argument with the Attorney General about a pointless issue. When someone poses a problem to me, the first thing I say is not, what does Section 3 say? The first thing I say is, what is the presumption of the law? I think that the law will allow you to do this, but give me 24 hours to look it up and confirm to you that there's no objection. I don't start by saying, bring one section of the Constitution. And then you can't read one section of the Constitution. You have to read the Constitution as a whole. The Constitution is the expression of our ideas, our values, and our will. So what is it that we intend to achieve there? And fundamentally, 43 people were slaughtered. There is a monumental security crisis across the nation. People don't feel safe to move interstate. This is a failure of federal government. And the president, the executive powers of the federal government reside in the hands of the president. The Attorney General is merely an extension of the president's powers. He serves entirely at the pleasure of the president. So what the Attorney General, as far as I'm concerned, is scrambling to find a legal reason to escape from the political responsibility of the president.
So even if he was going to be uncomfortable with questions that he would be asked, doesn't he have the right to say, well, I don't want to answer this question because of national
or he can claim executive privilege. That's the issues I can't discuss here in public, because part of the security infrastructure must be within my responsibility. Defer to me on that. But he has a responsibility to give assurance to the people and to answer questions. We need to know, is someone going to fix this window? What about the gate? How many security guards are you putting on duty? We need to know, because you want us to sleep here. And if it's not safe, we have to go somewhere else or remove you from power.
But there are also those who have said, well, if we're talking about the security architecture and all the problems, why not invite the service chiefs?
Sure, they can. But the service chiefs also serve at the pleasure of the president. So in the ordinary course of things, I would expect them to ask the service chiefs to answer about those detailed questions. Inviting the president is a political rather than a legal step, because they can gather information from anybody. It's quite likely that the service chiefs know more about this information than the president himself. But the fact that the call for the president is to respond to the emotional necessity that the leader of the nation, the father of the nation, should feel a need to speak to the nation in times of national crisis. That event was a significant event by itself, but it characterizes a collapse of security across the nation. And you can't sit down there picking your teeth with the suya we provided while the country's burning.
So for some people, this issue also throws up the question of whether the president has breached the Constitution in retaining the service chiefs even after they serve their military years. What do you think?
The president can appoint who he wants. The fact is that even those norms as to removing people serving for a specific period, this is less important than the effectiveness of these people in their office. So if you gave me two options as to what I should pursue, I would focus on the effectiveness of those individuals. He does exactly the same thing. It doesn't help us.
I also wanted to get your thoughts about the move by the governors to borrow from the pension fund, they say for infrastructure purposes.
Well, it's an alarming prospect, because I don't trust the accountability of the government and the governors for money that they take from the people. That is a fundamental problem. But the pension fund is a fund to be invested for the benefit of those who the money has been collected. So the question that arises is as to whether lending to the governors, not by force, but by an independent determination of those who administer the pension funds, whether that is something that is valid, viable. So if I want to invest in Eurobonds, nobody can misjudge me. They would say, well, there's a specific yield, it's safe, nobody can cancel it. But when you want to lend to political actors, how do you guarantee that that money is going to be used to increase the value of the fund? If government wants to raise money for infrastructure, they can borrow money commercially. They can raise a bond on international markets, they can raise a bond on national markets, which is subject to the scrutiny of private investors and will be subject to the scrutiny of the pension fund and its administrators itself. Then they would form a judgment and they would impose restrictions on the use of the money that would ensure that it retains its value. So of course, if you want to build a bridge from here to the Fourth Mainland Bridge and you're going to toll it, you can say, I can see the projections, it's going to be valuable to me. But if the governor can turn and use part of it to win the election in Ekiti State and the balance used to settle somebody in Katsina, how is that of value to the pension fund? Then it's a looting of the pension fund under the operation of abuse of political office. That is the issue. The issue is not that it can't be used for commercial purposes, including infrastructure. The issue is whether this is going to retain the value or whether allowing political actors to loot the fund is going to be prejudicial to the people who are waiting at the end of 40 years of service to receive the safety net that they've created for themselves. You can't loot a safety net with giving people the reason to believe that it's going to be safe.
I listened to your comments on the NSAS protest, the aftermath, and I'm curious to hear your thoughts on the panels. We saw that the police filed a suit, which they've not withdrawn, budging on the legality of the panels and saying that there was no power to do that. But what do you think about the constitutionality of powers, and what do you make of the panels themselves? Do you have confidence that we will see results?
First of all, I thought that it was hysterically funny that the police, which is an agency, the executive branch of government, would be opposing a mechanism activated by the executive branch of government to contain the crisis that had arisen from the NSAS protest. You've set up commissions of inquiry for a variety of reasons, to discover facts, to assuage public excitement and feelings, and to use it's a political mechanism to control the steam that's been generated by certain public events. So this is the purpose which this was created, and you're trying to give people some assurance that wrongdoing which has been sustained and systematic in the police over the years was going to be inquired into by an independent and impartial tribunal. The fact that the police could act in the way that was done and instruct a senior advocate of Nigeria, and the senior advocate of Nigeria accepts the case, which was repudiated a few days later, shows both a collapse in the executive function in the government and a collapse in the responsibility of lawyers who filed that case. Now, that has been withdrawn indicates that they realize that it's politically harmful and legally stupid to file an action to stop a mechanism that you yourself have invoked. For the IG of police to say he doesn't know what certain formations of his force are doing is a dereliction and a recognition that he failed. So it worries me that you create a commission of inquiry, and I was worried from the start about whether the army or the police would respond to those inquiries. But whatever the inquiry decides, it can discover facts if it has the cooperation of institutions, but it cannot make any recommendation that is valid or effective on the federal government. So to that extent, it seemed to me that these tribunals were diversionary and pointless. But they may have value in that if people have confidence in them, they will express on record events which may be the subject matter at some time in the future of legitimate criminal action. Because the stories that we're hearing in these tribunals are of brigandage and violent disregard of the law by institutions of the government. This makes it difficult for those institutions to tolerate this inquiry. But if those facts go on record, Whether they want to put the reports in a dust-gathering cupboard or not, the people can hear what is going on. And this is a measure for holding government accountable. And it's important by its own self whether the tribunals are effective or not. I don't know about the personnel, again, the character and the motivation of the people who sit on these tribunals is important to the outcome. And I'm not able to comment about the people who are in a variety of panels across the country.
Welcome back. The annual conference for Justices of the Court of Appeal is the traditional capstone to the court's calendar year, and it provides an opportunity to feel the pulse of the justices of the court on several issues. This year's conference was, however, a little different because it was preceded by a walking retreat for the justices, which is a first. It's also the first time the conference is holding in Lagos, and it gave the justices an opportunity to see firsthand the heavy impacts the court suffered following the hijack of the NSAS protest by hoodlums. Members of the bench and bar gathered here for the annual conference of the Justices of the Court of Appeal. The president of the court, who welcomed everyone to the conference, says this has been a particularly challenging year for the courts, especially because of the COVID-19 pandemic and then the NSAS protest. She says that despite these challenges, the commitment of the court to speedy delivery of justice remains unbowed. Aside from COVID-19 special panels, the Court of Appeal also deployed special panels to decongest matters pending in the courts. A good example of this is the newly introduced walking retreats, which first held in Abuja.
While the panels were sitting in Abuja, 3 special intervention panels, 2 of which were deployed to Port Harcourt and 1 to Makurdi, also helped to decongest those divisions. This week, our justices sought to hear a total of 345 appeals, comprising of 289 commercial appeals, 10 human rights appeals, and 46 criminal matters. We are particularly keen to hear commercial appeals because of the potential multiplier effect that these cases have in strengthening the wider economy and creating employment for the teeming youth and citizens of this beloved country of ours. Despite our best intentions, it is sad to see that some lawyers belatedly writing letters of adjournment and either frivolous or unfrivolous requests. Some learned counsel, after being served hearing notices and upon being invited to reconcile their files by the litigation department, suddenly woke up to the need to file applications to regularize those processes. We are forced to hear 120 motions for regularization of processes in order to ensure that appeals were ready for determination. Though we do not intend to mention the names of the chambers of these lawyers, one must warn that such antics by members of the bar will not augur well for justice delivery and must be stopped.
The Chief Justice of Nigeria, who declared the conference open, was represented by a Justice of the Supreme Court at the event. He used the opportunity of the conference to remind the Justices of the Court of Appeal to continue to give their best.
I wish to make it clear that the challenges and the way forward for the Court of Appeal are very pertinent issues that should give all of us sitting here serious concern. You must raise the ante and rejig your attitude and commitment to your calling with a view to giving the best within you through the judiciary and the nation.
The Court of Appeal also deployed special panels to decongest matters pending in the courts. A good example of this is the newly introduced walking retreats, which first held in Abuja.
While the panels were sitting in Abuja, 3 special intervention panels, 2 of which were deployed to Port Harcourt and 1 to Makurdi, also helped to decongest those divisions. This week, our justices sought to hear a total of 345 appeals, comprising of 289 commercial appeals, 10 human rights appeals, and 46 criminal matters. We are particularly keen to hear commercial appeals because of the potential multiplier effect that these cases have in strengthening the wider economy and creating employment for the teeming youth and citizens of this beloved country of ours. Despite our best intentions, it is sad to see that some lawyers belatedly writing letters of adjournment and either frivolous or unfrivolous requests. Some learned counsel, after being served hearing notices and upon being invited to reconcile their files by the litigation department, suddenly woke up to the need to file applications to regularize those processes. We are forced to hear 120 motions for regularization of processes in order to ensure that appeals were ready for determination. Though we do not intend to mention the names of the chambers of these lawyers, one must warn that such antics by members of the bar will not argue well for justice delivery and must be stopped.
The Chief Justice of Nigeria, who declared the conference open, was represented by a Justice of the Supreme Court at the event. He used the opportunity of the conference to remind the justices of the Court of Appeal to continue to give their best.
I wish to make it clear that the challenges and the way forward for the Court of Appeal are very pertinent issues that should give all of us sitting here serious concern. You must raise the ante and rejig your attitude and commitment to your calling with a view to giving the best within you through the judiciary and the nation at large.
The president of the bar, on his part, gives the assurance that the NBA will not be a clog in the wheel of progress. He also speaks to some issues agitating the bar.
I understand that this is a large court, and with the multiplicity of divisions that I am even advocating, there's always that risk that decisions that will emanate from this court may sometimes vary. My Lord, so even as we ask for more divisions, I think we have to put more structures in place to ensure that the court is speaking with the same voice, and the court is issuing judgments that that across board across board are uniform, so that there's no confusion on the part of those of us who work with those judgments.
This year, the Court of Appeal witnessed the largest elevation of justices to the Supreme Court. And with a depleted workforce, the court is optimistic that new justices will be appointed to bring it to its full strength of 90 justices so that it can continue to deliver justice speedily and fairly. And on the home stretch, we bring you a recap of some of the major activities from the judicial panels probing police brutality across the country.
We begin in Kaduna State, where the Judicial Panel of Inquiry into Acts of Police Brutality has held its inaugural sitting, with a total of 28 petitions received so far from the public. The sitting of the panel comes almost 2 months after it was inaugurated by the State Governor, Nass El-Rufai. The panel, chaired by Justice David Shiri Nyom, was inaugurated on October the 19th and was given 6 months to complete its assignment. At its inaugural sitting on Thursday, the chairman of the panel gives the assurance that the panel will be fair, transparent and just to everyone, while urging victims of police brutality and other human rights abuses to come forward with their petitions. He also announced an extension of time for submission of petitions to January 29, 2021. In Edo State, The Judicial Panel of Inquiry for Victims of SARS and Related Abuses is set to review the case between one Solomon Aigbangbe against hoodlums who allegedly damaged his vehicle in the wave of violence that trailed the NSAS protest. The vehicle in contention is said to have been parked at the State High Court premises on the day of the attack. The panel has also scheduled for review the petition of the family of Udoji Ofangba. The panel also heard the petition of one Mercy Obazi, who claimed that her brother Hamilton died in the custody of SARS operatives and his body is yet to be released to his family for burial. The panel summoned one Officer Røck, the then head of the disbanded SARS, to hear his side of the story before adjourning to the 18th of December. In Lagos, the Council for the NSAS protesters, Mr. Adeshina Ogunlana, has asked the state's Judicial Panel of Inquiry and Restitution for Victims of SARS-related abuses to summon Governor Babajide Sanwo-Olu and 12 others. Besides the governor, the others named in the application include Minister of the Federal Ministry of Works and Housing, Babatunde Fashola, SAN, the Chief Executive Officer of Loadside Promo Media Limited, Seyi Tinubu, Managing Director, Oriental Hotel, Divisional Police Officer, Maroko Police Station, and Likki Concession Company officials in charge of information technology, intelligence, and security. Others are officials of 7 private and government-owned hospitals. In the application, the lawyer said that those summoned could provide information concerning the Likki shootings of October 20 or its aftermath. Away from the panel to the courtrooms, the former chairman of the defunct Pension Reform Task Team, Mr. Abdulrasheed Maina, collapsed in court during his trial on Thursday, the 10th of December. The federal government is prosecuting Mr. Maina on a 12-count charge of fraud and money laundering before a federal high court sitting in Abuja. The former pension boss slumped when his counsel Anayo Adibe was addressing the court on his client's no-case submission. The court had to rise abruptly to enable officials of the Correctional Service and relations of the former pension boss attend to him. Staying at the Federal High Court, Justice Inyang Ekwo has granted permission to a former Attorney General of the Federation and Minister of Justice, Mohammed Adoki, to travel for medical checkup at the United Arab Emirates. While ruling on Adoki's application for permission to travel, Justice Ekwo also ordered the release of his passport to enable him travel from December 15 to return on or before January 10, 2021. Mr. Adoki is standing trial alongside a businessman, Aliyu Abubakar, on a 14-count charge of money laundering. His trial is scheduled to resume on January the 11th. And we round off in Lagos with the reports that the trial of a former Speaker of the Lagos State House of Assembly, Adeyemi Ekuforiji, before a federal high court has been adjourned till February the 3rd. At the last proceedings on Wednesday the 9th, the EFCC prosecutor Ekene Iheanacho sought to call his second witness, Mr. Adewale Tai.